This is brought to you by Cook County's Commission on Human Rights. The purpose of this video is to describe the three-step screening process in compliance with the Just Housing Amendment to the Cook County Human Rights Ordinance. On April 25, 2019, the Cook County Board of Commissioners passed the Just Housing Amendment to the Cook County Human Rights Ordinance. To 1. Prohibit housing discrimination based on an individual's covered criminal history. 2. Require landlords considering an individual's covered criminal history to perform an individualized assessment of an otherwise qualified individual's criminal conviction history prior to denying them any application for housing. The Just Housing Amendment went into effect on January 1, 2020, with initial enforcement on February 1, 2020. The Just Housing Amendment includes several newer procedures for housing providers and seekers to be aware of and practice. The Cook County Commission on Human Rights wants to ensure that the public understands these procedures as clearly as possible. We are going to talk through the three-step screening process together. In compliance with the Just Housing Amendment, screening a housing applicant for a potential unit involves a three-step process. Step 1 of the screening process is pre-qualification. During this step, a landlord may screen a tenant to determine whether the tenant satisfies all the application criteria, such as income requirements, rental history, credit score, pets, etc. During this step, landlords cannot formally or informally ask applicants about prior justice involvement. Landlords can no longer include a checkbox on housing applications that ask whether an applicant has a criminal background. When this first step is completed, the landlord must either pre-qualify the applicant based on all criteria except those related to criminal history, or 2, deny the application based on failure to satisfy the pre-qualification criteria. Step 2 is the criminal background check. It is important to note that within the Just Housing Amendment, a housing provider is not required to run a criminal background check. It is possible that a housing provider does not want to run a criminal background check, in which case, Step 2 can be skipped. If a housing provider chooses to run a criminal background check, they must provide a copy of the background check to the applicant within 5 days. A copy of the background check can be delivered in person, by certified mail, or by text or email. The background check should screen only convictions from the previous 3 years of the applicant. Any convictions older than 3 years may not be used to deny a housing application. If a conviction is found, the landlord must conduct an individualized assessment. Step 3 of the screening process is the approval or denial of housing application and right to dispute. If the applicant passes Step 1 and 2, they will receive notification of an approval. If they did not pass Step 1 or Step 2, the landlord may deny the application, and the applicant has the right to dispute the denial. Landlords must provide a written explanation of why the denial is necessary to protect against demonstrable risk of harm to persons and/or property. This concludes the three-step screening process involved in determining compliance with the Just Housing Amendment to the Human Rights Ordinance. If you have any questions or believe that a landlord or housing provider violated the Just Housing Amendment, contact the Cook County Commission on Human Rights. If you're a landlord or housing provider in Cook County and are looking for clarification, please contact us. We recommend you learn more on our website at bit.ly/HR Commission, and more specifically about the Just Housing Amendment at bit.ly/Just Housing Amendment. Our email is human.rights@cookcountyil.gov. And our phone number is 312-603-1100. This does not constitute legal advice and is for educational purposes only.